So hello and welcome everyone to the webinar series of the Shorenstein Asia Pacific Research Center for Winter Quarter 2021. Thank you very much for joining us. Our colloquium series this quarter is on Asian politics and policy in a time of uncertainty. And all of our webinars are held at this time slot, 4 to 5 p.m. Pacific time, starting with today's webinar on the politicization of the judiciary in South Korea. The series will continue with each of our programs contributing an event every week or every other week. You can see more information on our website. February 2nd on Pakistan's response to national crises, February 9th on Abenomics, 16th on Indonesian democracy, March 2nd, demographics and innovation in Asia, and March 9th, the political economy of e-commerce in China. We welcome you to join for those webinars in the future. And today we'll turn it over to the Korea program for today's event.
Okay, thank you very much, Karen. I would like to welcome you again to today's event. We have a distinguished lineup of legal scholars today, and I'm very delighted that they can join us on this panel, discuss the politicization of the judiciary in South Korea. But this topic is also quite relevant today in the US as well, with the debate surrounding the nomination of Supreme Court justices. Just wanted to point out that we did this theme that we decided upon came about from a conference we did last year on the democratization of South Korea, and a book volume will be coming out related to that. So please be on the lookout if this is of interest to you. Also, we have another event coming up in a couple of weeks, focused on democratization of South Korea, or more on are liberals truly liberal in South Korea? And we will have BJ on from Kyung University and Aram Ha from the University of Missouri join us on that panel. Okay, so without further ado, I will introduce today's event. I'll first introduce our three panelists in order they will speak, and then hand over the screen to them. First, we have Professor Seongwook Heo. He is Professor of Public Law at Seoul National University's Law School. He teaches administrative law, environmental law, and law and economics. He received his PhD in law and LLM and bachelor's degree in economics, all from Seoul National University. His research intersects topics of economic regulations, utilizing economic analysis. He is mostly interested in laws concerning climate change, energy, food safety, IT and privacy, and the judicial system. Prior to joining the SNU Law School in 2006, he had served as a judge of Seoul Central District Court in Korea. Professor Heo, thank you for joining us.
Thank you, Professor Lee.
After Professor Heo, Professor Julie Seok will be speaking. She is the Florence Rogatz Visiting Professor of Law and Research Scholar at Yale Law School and Professor of Sociology and Political Science at the Graduate Center of City University of New York. She has a JD from Yale Law School, where she studied on a Paul and Daisy Soares Fellowship for New Americans, and a doctor in philosophy and politics from Oxford University, where she held a Marshall Scholarship. Professor Seok is an interdisciplinary legal scholar focusing on women as constitution makers at the intersection of law, history, sociology, and politics. Her 2020 book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, tells the stories of the forgotten women lawmakers and lawyers who shaped the ERA over a century. She's a frequent commentator in the media on legal issues affecting women. Thank you for joining us, Professor Seok.
Thank you so much for having me.
Okay. And finally, we have Professor Tom Ginsberg. He's the Leo Spitz Professor of International Law at the University of Chicago, where he also holds an appointment in the Political Science Department. He holds a BA, JD, and PhD from Berkeley. He currently co-directs the Comparative Constitutions Project, an NSF-funded dataset cataloging the world's constitutions since 1789 that runs the award-winning Constitute website. His latest book is How to Save a Constitutional Democracy, which won the Best Book Award from the International Society for Constitutional Law. He's a member of the American Academy of Arts and Sciences. Hello, Professor Ginsburg. Thank you for joining.
Thanks for having me.
Okay, then now without further ado, I would like to directly invite Professor Heo to share his remarks.
Thank you, Professor Lee, for the kind introduction. So I'm very much honored and delighted to join this wonderful event. The topic I want to share some idea with you today is the politicization of the judiciary in South Korea, mostly focused on the challenges in maintaining the balance of power. So let me first begin with the background and some premises. So less than 4 years, 4 years, have passed since the inauguration of President Moon in Korea. So for those who lost in the field of politics, that 4 years could be felt as eternity. However, to evaluate the constitutional meanings of what has happened in Korean politics during that years and its implications on democracy and on judicial independence, time has not passed yet enough. So it is not yet fully the past, or rather it is the present still ongoing around us. So therefore, I should point out that I will try my best not to be judgmental too much. So instead, I will try to summarize and describe events that happened during that years around the judiciary from an objective perspective. So let me go to the Constitution of Korea. So like many other democratically advanced countries, the Constitution of Korea, South Korea, is also strictly prescribing the independence of judicial power. And so let me add one more point, which is about the dual highest court system, so which is the Constitutional Court and the Supreme Court. So in Korea, the Constitutional Court is the highest court in reviewing the constitutionality of legislations and agency actions. But the general court decisions cannot be reviewed by the Constitutional Court. So therefore, the Supreme Court is the highest court in general, like in general cases like civil, criminal, or administrative litigations. So there is a quite interesting institutional or historical story about how the Korean constitution could take this system, but I will skip that part in this talk. Let me go to the story of the impeachment of former President Park Geun-hye and its impact on the composition of the Supreme Court in Korea. So originally, the term of former President Park was to continue until February 2018. So within that term, the former president was due to nominate a new Chief Justice and 4 more justices of the Supreme Court. But as she was impeached on March 10, 2017, those slots all came to President Moon, so enabling him to nominate during his term 13 among 14 justices in total. And the situations of the Constitutional Court was no different. So one concerning issue with this situation is that it is generally evaluated that the Moon government is highly ideological or liberal and does not show much hesitations in packing up the court with judges who share common political preference with them. So this is quite different from what the previous government generally did. So in the past, the Supreme Court justices were mostly chosen from the traditional elite group judges who were well-careered during their judgeships and were acknowledged about their capacity as a judge through peer competitions. So as of now, in the January of 2021, so among the 11 justices, including the Chief Justice Kim, so who are nominated by the President Moon, more than half justices are from the so-called Uribop study groups inside the court, or Minbyeon lawyers group who are claiming that they are active for democracy. So both of which are well known as highly liberal lawyers group. So this is quite unprecedented and can easily lead to some concern of the balance of power. So not just in the judiciary, but also in the overall governing system. So let me go to the story about so-called the fighting against the deep-rooted evil. So in the judiciary in Korea, the beginning of President Moon's term, the new government did its best to change the Supreme Court fit to its political preferences, as I mentioned. And one judge working as a key member of the International Human Rights Law Studies Group, so which was following the ideological study group of 우리법 연구회 inside the court, moved his position to the Blue House directly from the court as a judge to the Blue House as a secretary to the president for legal affairs. So this was quite inappropriate in terms of the principle of separation of powers and the independence of judiciary. So then the new Chief Justice Kim was nominated, and despite not having any prior experiences as a justice of the Supreme Court. So maybe his main career credentials seem to be that he used to be the leader of the both study groups. And the earlier days of Moon government were characterized by harsh investigations and punishment of former government officials, including former President Park Geun-hye and Lee Myung-bak. So major figures of the judiciary, including the former Chief Justice Yang and Justice of the Supreme Court, and many other judges, could not escape the investigations and convictions. After investigations and political attacks, so the former Chief Justice Yang was finally arrested and convicted in a criminal trial, so which is quite unprecedented event in Korea, not just in Korea, but also in many other countries, maybe. Then let me skip other part and let me go to some major cases and before and after the Moon government and Chief Justice Kim. So let me first go to Supreme Court cases. Here are some cases and major decisions of the newly composed Supreme Court that shows quite a different attitude in dealing with political cases compared to the former Supreme Court. These decisions may be quite controversial in the sense that they took quite different reasonings compared to the past Supreme Court decisions. And some of them might be understood as problematic. So in the sense they compose quite unusual reasonings to justify the conclusions. Let me first go to the so-called the first workers during the Japanese colony case, which was delivered on October 2018. So quite early time of this Moon government. So this was a case about whether the Japanese companies with origins in companies who had been complicit in war crimes during World War II were liable for damages to the plaintiffs who had worked as laborers during the war period. So this case had quite a number of difficult legal issues to get over for the plaintiffs to win the damages against the defendant company. So I'll skip that part. And somehow finally, the Supreme Court, en banc, decided that the defendant company was liable to the plaintiffs. The decisions ruled that the plaintiff's claim had not been included and resolved by the San Francisco Peace Treaty in 1951 and the Korea-Japan Claims Agreement in 1965. And of course, the Japanese government was not agreeing on this point. And this conclusion was also different from the attitude of the Korean government of President Roh Moo-hyun. So in Roh's regimes, the Korean government did actions to compensate the plaintiffs so with a special Korean budgets on the special legislations. And following these decisions, the district court judge allowed plaintiffs to seize the assets of the defendant company located in Korea. So, and these decisions brought the Korea-Japan diplomatic relationship to its worst, I think, in the post-war period. So both countries issued retaliatory measures from economic sanctions to immigrations. This dispute has not been yet solved. So one interesting but quite unfortunate story about the background of this case is that the former Chief Justice Yang was investigated and convicted on the ground that he had deliberately suspended the trial and decision of this case, in collusion with the Ministry of Foreign Affairs of former President Park's government, so in order to gain political support for reforming the appeal system to the Supreme Court. So he is still under trial. So I'm not sure whether he would be sentenced guilty or not. So we need to wait and see. Let me go to the second case, which is about the Gyeonggi Province Governor Lee Jae-myung, who is quite popular in Korean politics now. This case was delivered on July last year. So this is a criminal case of Governor Lee Jae-myung, who is a leading candidate of the ruling party for the next presidential elections. And it was charged that he had violated the Public Election Act, which prohibits false statement during campaigns. So he was asked by the opponent candidate whether he forced his brother to be hospitalized to a mental hospital by using his authority as at that time as a mayor of Seongnam City. So he was charged that he falsely stated no to that question. So up until the appellate court, he was sentenced to a monetary penalty of 3 million Korean won, so on the ground that his statement was false. And according to Korean Election Act, once the winner is sentenced more than 1 billion Korean won, he will lose his positions and he cannot run for another public office either. Surprisingly, the Supreme Court en banc, led by Chief Justice Kim, reversed the case and remanded this case to the appellate court with the intent of being not guilty. So the opinions of the justice was split. The majority of 7 justices voted for not guilty, and the minority of 5 justices voted for guilty. And 5 justices, including the Chief Justice, among the 8 total justices who had been nominated by President Moon until that time, voted not guilty on the ground that his statement was not an actively false statement. So rather, he was passively saying no his opponent's question. And Supreme Court ruled that this kind of no or false statement is not enough to be guilty according to the Election Act. So it is not yet clear so how much political reasoning was involved in this case, but this decision is at result is having a great impact on Korean politics, considering the fact that he's running as a most powerful candidate for the next president, leading as the first opinion polls. But I can say that the general attitude of the Supreme Court on political issues has changed quite a lot after the reconstitutions of the court by the new government. So maybe by more actively getting involved into political decisions. And let me go to the maybe last cases. This is about the Labor Union of Teachers Association case, which was delivered the September of 2020, quite recent case. So the Labor Union Act of Korea states that when a union accepts a person who does not work in the company as a member of the union, then the union cannot be legally protected by the law. So until 2013, the Union of the Teachers Association, 전교조, included as members those who had been fired from their jobs due to illegal activity. And the Ministry of Education ordered a correction of this status twice, but the union did not comply. So under this context, the Ministry of Education delivered to the union notice that the Union of Teachers Association is no longer a legally protected union under the Act. And the union requested to the Supreme Court the cancellations of the Ministry of Education's Act, and also requested the Constitutional Court to review the unconstitutionality of that labor union act. So until the appellate court, yes, the plaintiffs did not win the case, and their request was also rejected by the Constitutional Court. So in that context, the general expectation on this case at the Supreme Court was that the claim would be again rejected. But yes, also quite unexpectedly, the Supreme Court en banc accepted the union's claim, canceled the notice, and remanded this case to the appellate court. So another unexpected point was the legal reasoning the Supreme Court to accept the union's claim. The majority opinion reasoned that under the kind of Korean version of non-delegation doctrine, so there should have been delegation from the statute, so not only about the qualification of the legal union, but also about the notice process for the delivery of the notice. So for the notice to be legally valid. And against this majority opinion, so there were different and opposite opinions from the other four justices. And there are quite many interesting story only for the lawyers in this case, but I'll skip that part in this case. But still, we can find and witness kind of the different attitude of the Supreme Court on political issues. So other than that, I can find and talk about many other interesting or maybe kind of related to politics cases, like especially lower court cases, like the validity of the disciplinary measures on the chief prosecutor Yoon Sung-yeol, so by the Ministry of Justice Chu case, or quite still another recent case, the monetary damages claims by the Comfort Women against the Japanese government case, or a case about the owner of Samsung, Lee Jae-young's criminal case. So yes, these are cases on the lower court, but and still quite meaningful cases for the politicization of the judiciary or judicialization of the politics in Korea. So, but because of the time limit, so I will skip that part and I'll finish my talk now. So thank you, Professor Lee.
Okay, thank you very much, Professor Hall. So we'll now turn to Professor Seok for her remarks and assessment on cases in South Korea as well.
Great, thank you so much. And thanks for the very fascinating and provocative paper, Professor Ha. So I want to focus on the concept of politicization and whether it's a good thing or a bad thing in certain contexts, because I think Professor Ha's paper highlights at least two ways in which the judiciary has been politicized. The first way is by way of judicial appointments. He notes that President Moon has had the opportunity to shape the Supreme Court and the Constitutional Court majorities because of the very large number of judicial appointments that have become his to make due to Park Geun-hye's impeachment. So of the 11 appointments that he's made, which is a lot of appointments, more than half of them have been made from liberal lawyers groups, including Uri Bub Study Group and Minbyeon. which have a liberal reputation and also a strong orientation towards human rights. The suggestion, particularly in his discussion of the forced laborers case and the Supreme Court, is the judiciary is bending ideologically to the left on these issues and therefore politicized in that sense. The second sense in which we talk about politicization of the judiciary in Professor He's remarks is that the judiciary is showing a lack of independence and therefore being politicized in that sense by way of its approach to criminal prosecutions, specifically that Moon's allies are being treated differently, perhaps more mercifully in the context of prosecutions for things like violations of election law. This is the Governor Lee case. But then again, the Moon judiciary is being harsher on with regard to criminal prosecutions of non-allies. So I think these are two different, although perhaps connected ideas of politicization. And in the interest of time, I'm going to focus more on the first concept and draw some comparisons to the United States. So I'm sure it's no coincidence that both the Supreme Court and the Constitutional Court of Korea, with most of the judges now nominated by Moon and his party on both courts, that there has been a shift in the jurisprudence in a direction that arguably expands human rights, and particularly with regard to the claims of forced labor and sexual slavery during World War II. These claims are claims from decades ago that are being brought in ordinary civil litigation now in the lower courts, both against the Japanese government and Japanese companies. And as Professor He mentioned, we had the Supreme Court's decision in 2018. So that was a case where the forced laborers sued New Nippon Steel corporations and lower courts had awarded damages. I believe it was 100 million won in damages to each plaintiff, despite the defendant's argument, the Japanese companies, they argued that all these legal claims by the forced laborers were extinguished by a 1965 treaty, the claims agreement between Korea and Japan, which was undertaken during Park Chung-hee. So the Supreme Court in 2018 took what you might describe as a human rights perspective on that legal argument, rather than an ordinary private law perspective with regard to the remedies demanded by the forced laborers in that litigation. The Supreme Court read the treaty as extinguishing legal claims only for property claims, such as unpaid wages that the laborers might ask for. But the judges on the Supreme Court actually viewed the forced laborers' claims as damages actions for human rights violations stemming from Japan's illegal war of aggression. Specifically, and I'm quoting from an English translation of the case, these are claims premised on, quote, the inhumane and wrongful act of the Japanese corporations directly related to Japan's unlawful colonial rule over the Korean peninsula and its war of aggression. So close quote. And so therefore, these claims were outside the scope of the treaty. At least that's how the Supreme Court interpreted it. And they said that the treaty only dealt with financial, civil debts, and credit relations between the two companies. And obviously, if you take this view of the treaty, it's going to have an impact also on the claims by the so-called comfort women, those who were forced into sexual slavery during World War II against the Japanese government, or perhaps in Japanese companies as well, even though in this 2018 decision, the comfort women's claims were not before the Supreme Court squarely. So even before the justices nominated by President Moon decided this case, as Professor He mentioned, the case was already the subject of controversy about judicial independence, because ex-Chief Justice Yang, whose term expired in 2017, was prosecuted because of his management of the forced laborers case. It was alleged that he met ex parte with the Korean law firms representing the Japanese companies, and he's now accused of conspiring with Park Geun-hye's government and improperly delaying these cases to avoid creating a diplomacy headache for then President Park Geun-hye. And of course, what happens politically in 2015 is that Park Geun-hye achieved an agreement with Japan purporting to settle once and for all the claims of the comfort women. So in 2015, and this was a deal that was highly unpopular, and many of the comfort women themselves felt that it was a very inadequate agreement to fully recognize and compensate the violations of their human rights. So, and I want to point out that, of course, this is actually a serious question in terms of what should the judicial involvement in such claims be. Ordinary civil litigation to seek compensation for human rights abuses. That's something that judges in many jurisdictions, including very notably in the United States, approach with great caution, largely because of the danger of getting embroiled in foreign relations matters that are thought to be the province of the political branches. So, and it is actually the case that the comfort women attempted to bring a civil lawsuit against Japan in US courts, in federal courts in the United States in the early 2000s. And the US Court of Appeals for the DC Circuit dismissed in 2005 in the Hwangum-ju versus Japan case on the grounds that the lawsuit involved a political question that should be resolved by the executive branch and not by judges, or at least not by US judges in a case involving foreign citizens against a different foreign nation. But of course, it is baked into US political question doctrine, which judges themselves articulate in US courts, that judges should not get involved in questions that are really political matters for the president or for the legislature. So, but nonetheless, in 2019, the Korean Constitutional Court, also with many judges named by Moon, perhaps emboldened by the Supreme Court's ruling the previous year in the forced laborers case, the Korean Constitutional Court then expanded the human rights claims in ordinary civil actions. On the one hand, so this is the comfort women petition. On the one hand, the Constitutional Court claimed it was not getting involved because it dismisses the constitutional complaint by the comfort women, but its justification for not getting involved got itself extremely involved in Japan-Korea relations. The decision declared that the agreement that President Park Geun-hye reached with Japan in 2015 was actually not a legally binding treaty. So there, the Constitutional Court drew on the Korean Constitution as well as principles of public international law to conclude that the agreement settling the claims of the comfort women was not a treaty and therefore could not bind the comfort women's civil claims against Japan, could not extinguish those claims. And this is a really fascinating decision. It has a real Marbury versus Madison-like quality because the court is saying, we don't have power over your constitutional complaint because there was no treaty that violated your rights. But by the way, we do have power over the much bigger and more loaded political question of whether there was a treaty at all. And so it's a very interesting move. The comfort women were going before the Constitutional Court claiming that the 2015 agreement would violate their constitutional rights to dignity and due process if the Japanese government were allowed in litigation to rely on that agreement as a defense to civil liability. And the Constitutional Court says, well, because you can't rely on the treaty to extinguish the claims because the treaty is not law, these women don't have a constitutional claim. But the obvious upshot of that reasoning was that, of course, the women could proceed in their civil lawsuit before ordinary courts against the Japanese government, seeking damages against Japan for their human rights violations. And it's quite noteworthy that, I mean, it's there's a lot of technical legal reasoning that goes on. But one thing that I find noteworthy about the decision is that the court does take a real human rights victim-oriented perspective in understanding what's like why the 2015 treaty cannot bind these women. The 2015 treaty, the Constitutional Court says, was made, or I guess maybe we shouldn't call it a treaty. The 2015 thing that Park Geun-hye negotiated with Japan did not take the victims' opinions sufficiently into account and therefore could not bind them. So, and of course, what happens after that is that the victims then can proceed, and they do proceed in Seoul Central District Court against Japan. And I think just a few weeks ago, January 6th, the Seoul Central District Court awarded them 100 million won, about 91,000 US dollars in damages in those lawsuits. And so you can see the politicization that Professor Ha is talking about, these cases are going to judgment because of who is sitting on these courts, people who have a human rights orientation, and they're taking a human rights approach to their understanding of both the 1965 treaty and the 2015 agreement. And ex-Chief Justice Yang feared, correctly, that such judicial decisions would actually cause a diplomatic headache, which it has, because Japan's now infuriated and there are all kinds of economic consequences to all this, and retaliations and so forth. So, so there's no question that we're seeing a more human rights friendly court than we had in the past. But the question I want to raise is whether we should think about this as an ordinary form of politicization, by which I mean the kind of politics that constitutional designers envision when they have political actors like the president nominate the judges to the apex courts. To some degree, I would say, in a constitutional democracy, courts' decisions must be responsive to the people to retain their legitimacy. Courts lose their legitimacy when their rulings depart too far from what the people are ready for. At the same time, I think we also understand that rule of law principles instruct that if decisions appear overtly partial to a particular political position or ideology, that delegitimizes the court and is vulnerable to criticism. So if we, just to take those ideas into the American context now, just think about the controversy that took hold over the confirmation of Justice Amy Coney Barrett just a few months ago to the Supreme Court. The recent history of Trump's judicial appointments offers a very interesting parallel to the Korean story, but the politics are totally flipped, because Trump has frequently vowed, when he was running for president, he said that he was going to appoint conservative, pro-life justices who would overturn the Supreme Court's longstanding precedent on abortion rights, namely the case of Roe versus Wade. And so one analogy you could draw, so Korean liberal lawyers have Uri Bup and Min Byun, who supplied Moon's judicial picks. American conservatives have the Federalist Society, and the Federalist Society has been the source of all of Trump's judicial nominations at every level, not just the Supreme Court, but all the lower federal court judges as well. And all three of his Supreme Court justices were members of the Federalist Society, including Amy Coney Barrett. And additionally, it was no secret when Amy Coney Barrett was being confirmed that she was pro-life. In her confirmation hearings, there was a lot of questioning about a petition that she once signed at her church that denounced Roe versus Wade, the abortion precedent, as having a barbaric legacy. Of course, she didn't answer any questions, because judicial nominees never answer any questions about how they're going to rule on a future abortion case. And indeed, there are a lot of abortion bans that are being challenged in the lower courts right now. And so eventually those are going to go up to the Supreme Court. But it's very interesting that the fact that she had such a strong political leaning on this issue that was publicly known led some of the liberal politicians in Congress to act as though she was not really qualified to be a federal judge, let alone a Supreme Court justice. So even when she was being confirmed to the Seventh Circuit, the appellate court, there was a lot of talk of her dogma and whether or not she was suited for the judiciary because of her dogma. And the dogma was totally about her religious views on abortion. And also, I think a similar dynamic that you see, I mean, Professor Ha mentioned that some of the judges that are human rights friendly did not have the same kinds of experiences as justices that were picked in the past. I think with some of Trump's nominees to the lower federal courts, similarly, there have been criticisms that their main qualifications are being conservative and that they don't have the same kind of trial and other forms of legal experience that you should expect from a nominee to the federal bench. So, and of course, just 2 weeks ago, just continuing on this line about politicization and abortion in the United States, 2 weeks ago, the Supreme Court issued its first abortion decision, arrived at with Amy Coney Barrett on the court. I mean, it's a very minor order involving just a pandemic era abortion regulation, But this is a decision on which Amy Coney Barrett and the conservative justices, all of Trump's nominees, upheld the restriction on abortion, and the 3 liberal justices did not uphold it. And in fact, Sotomayor and Kagan wrote a fairly long dissent criticizing it. But here you could see the same pattern, justices that are picked from the conservative organization, predictable how they're going to rule on issues that are politicized, like abortion. And so you might say that this is just something that's expected and intended from the politicization of the judiciary, although perhaps on the another side of the political spectrum than what you're seeing in Korea right now. And so I think this raises a genuinely intriguing question as to whether the American story represents an abnormal politicization of the judiciary or the level of politicization expected when you make the judiciary politically accountable by empowering the political branches, like the president and the Senate, to pick the judges. You might say that the Korean example represents the same level of politicization, only in a leftward rather than a rightward direction. And so you might also think about that question in relation to the Korean trajectory with regard to abortion. It is my impression that abortion is not the source of intense political polarization, at least at the same level in Korea as in the United States, although I'm curious to hear some of your thoughts on that. But it is worth noting that abortion is another area in which you see a real shift on the Constitutional Court since in recent years, because in 2012, the Constitutional Court upheld the criminal abortion statute, which only allowed abortions in the case of rape, fetal defect, or risk to a mother's health or life. Now, it was widely acknowledged that even though the law authorized criminal fines and prison time for doctors and women in that context, you had a 4-4 split in 2012, but in 2019, the Constitutional Court, with 2 female justices, newly appointed, struck down the criminal abortion statute, and this led to a liberalization of abortion access by statute just 2 months ago. So, so I want to just end by pointing us to think about an ideal of an apolitical judiciary. I think you see a version of that ideal, I think, assumed in Professor He's paper, and I think most judges in the United States, both liberal and conservative, describe their work as being empty of policy preferences and apolitical in that sense. But I think that we haven't really taken that view of the court or of the judiciary all that seriously, because our constitutional design injects some degree of politicization through the mechanisms of appointment. So I guess the question I'd like to just end with is, what is the right degree of politicization in these matters in terms of where the judges come from and how they end up deciding?
Okay, thank you very much, Professor Seok. That's a fascinating discussion. With that, we'll head to Professor Ginsburg.
Terrific, and this will follow very much on Professor Seok's comments. And just again, thank you so much, Professor Heo, for a wonderful paper. I learned a lot about the recent developments in Korea, and I tend to agree with your analysis of each of these cases. But I thought what I would do is give a little broader perspective. So just the way I see these dynamics of judicial empowerment and politicization as they play out in many countries, with, of course, a focus on South Korea. So, if you go back, 30 years or something like that, you found in South Korea a judiciary which I think was really pretty high quality, but didn't have a big scope of activity. That is, one way to think about this is you have these 2 dimensions. There's the degree of judicial independence from politics, and then the kind of scope of activity. How much of the society are they really governing? And of course, there weren't very many judges, as you all know. It was very hard to pass the bar exam, 1%, 2% pass rate, 5,000 lawyers for the whole country. But those lawyers were pretty good. In order to pass the exam, you had to be really smart. And once you did, you basically could be very autonomous. And so you had a high quality judiciary. But if you really wanted to understand what was going on in South Korea, you had to look elsewhere. You had to look to the chaebol, you had to look to the bureaucracy, you had to look to the networks of people that were really making the society run. So the judiciary didn't have much scope, even if it was relatively independent. Then, of course, we have the dynamics of democratization. And that happened at a time where globally we were seeing judges be empowered, right? There was a time when constitutional courts were expanding. Everyone thought the law was neutral. We should expand the rule of law. And of course, that's what happened as a matter of the constitutional design. Now, it also turned out that there was this group of activist lawyers, and you talked about the Minbyun, People's Solidarity for People's Democracy, with a participatory democracy, Pak Won-soon's operation and such. And these liberals kind of came in and said, well, look, we've got these courts, they seem to be pretty powerful, let's start to bring cases. And they were very successful. And those to me were not really partisan cases, they were democratizing cases. And I mean, if you look back to the 1990s, they did all these amazing things. They got the National Security Act interpreted in a much better way. They ended a lot of the repressive apparatus with media control and things like this. And you gradually saw this kind of expansion of judicial power. So now you see this kind of independent judiciary, but expanding in power, and particularly the constitutional court, right? And maybe that, stage reaches its apex possibly with the Nomuhyun impeachment, where the constitutional court says basically, yeah, he did some wrong, but we're not going to kick him out, which means that they are the ones choosing who's going to be leader of the country. And there's nothing in the Constitution which gave them that power. They made that up, just as they made up the idea that Seoul was the eternal capital city and Nomuhyun couldn't move it. So, these are situations. That's where you start to see the judiciary going from being independent, expanding its scope, to really judicializing politics, taking major decisions where the public had voted or the political process had, operated to remove the president, saying, no, we're not going to allow that. So that's really, to me, a turning point. And I should say also that I think part of this story is the actions of those liberal lawyers who Professor Heo obviously identifies. I just want to recall that about 15 years ago or more, I was doing research on this very topic, and Pak Won-soon was in Stanford. I think he did some time there visiting for some reason. I don't know exactly why or when precisely, but I interviewed him. I went there and I interviewed Mr. Pak. And he told me, PSPD, we aspired to be, we were like a political party that never wanted to take power. In other words, we wanted to advance certain agendas, but we didn't want actually to hold power. And well, what happened? He did want to hold power. He got elected. And a lot of those guys transferred that sort of legal expertise into actual political power. And to me, that was kind of a, that's another sort of juncture. That decision that they made, and it's a conscious decision. They're going to start playing party politics. Well, party politics are dirty and messy everywhere. And you can't really have the autonomy that we have in academia or even in the law of deciding decisions correctly once you start to play that game. And so that's sort of some background on how I see how we got to where we were. You start with a autonomous but not very political judiciary. Because it's autonomous and independent, people give it a lot of power. It expands its role. But once it becomes powerful, the temptation to actually try to control it comes in. And so once you have the judicialization of politics, you get the politicization of the judiciary, to use the phrase Professor Heo has identified. So then what happens? Well, in a book that I wrote with Professor Nuno Garupa a few years ago, we kind of talk about these cycles. We say, well, once you get to that stage, there's going to be pressure now to move it towards more accountability and to sort of decrease the scope of judicial activity and to try to clean things up. I don't know if that's going to happen in South Korea. The fact is that it is, pretty messy situation right now. A kind of other element of all of this is that when we talk about legal institutions, we tend to focus on the courts, but in South Korea especially, and probably everywhere, prosecutors are their own beast. And you don't actually mention the prosecutors in your paper, but that's part of the story here. Going back to Park Chung-hee, prosecutors are always sort of the agents of the Blue House, or were, at least when I was looking at it. And your story seems to confirm that. that the prosecutors could go after poor Chief Justice Young. I feel sorry for the guy. All he's trying to do is to, expand the role of the courts and make them operate more efficiently, and he gets, thrown under the bus. So the prosecutors are kind of a wild card. And no matter how clean a politician you are, once you get into power, that's a major instrument of power, and it's just too tempting to use. And so it's really hard to get out of this without the prosecutorial reform. And that, of course, has been a major issue this last year with Seongwook and, and threatening Moon, saying, well, we're going to prosecute reform, and saying, no, you guys are out of here. So it's a really tough one to crack, partly because the ethics standards in South Korea are incredibly high, right? If you can't lie during a campaign, think about it, what that would mean in the United States. We have, 535 members of Congress. None of them would pass that test. So it's a very it's very interesting place, South Korea. Really high ethics standards, very mobilized public, really demanding ethical behavior, and using the law to control those almost Confucian virtue that you want out of the politicians. I think it's really interesting, but I'm glad I'm not trying to do anything in that society, because it's pretty hard to manage, I guess, is maybe what I would say. So with all that said, I want to make one final comment, which is, how do I see some of these cases? Now, I think the judges, given this situation, they're in a political, really hot place, and there's nothing they could do to get out of it. Professor Sook referred to the United States Supreme Court. Clearly, Chief Justice Roberts was someone who was trying to reduce the temperature of the courts, right? Because his whole philosophy on the Supreme Court is, no, we're not going to decide that. It's got to be perfectly right. We want to make sure everyone has standing. No, we're going to decide on this little narrow technical issue rather than decide Obamacare was a bad policy. So he's trying to reduce the temperature, but it's really hard once you get there. The way I see the other wing of the American Supreme Court, and the way I see some of the cases you talk about, is almost like a populist court. So when you have these three, when you have the decision in the most recent decision of the U.S. Supreme Court involving Cuomo, I can't remember who it was against Cuomo. Oh, the Catholic diocese versus Cuomo. Basically, you have these judges who don't really need to do so, saying religious rights. You Democrats are trying to take away the religious freedoms of Americans, and they kind of have this overwrought decision because they're trying to appeal and to get their popular reputation. And I think that's what these wartime comfort women cases are, and forced labor cases, honestly. Now, I've spent a lot of time in Japan, and these cases are brought there too, right? And some of the Chinese laborers have won, most of the Koreans have not. I think that has to do with very technical reasons of law, rather than, but I feel like when the public is looking at these cases, they're saying, yes, we're sticking it to the Japanese. That's not really appropriate for the rule of law. So I tend to be with Professor Heo on this, and maybe a little bit in opposition to some of what Professor Sook was saying, though, if she didn't take a strong position. But I tend to feel like the law is not the right place to resolve these things. So with that, I will pause and turn it back to you, Young-Suk.
Okay, thank you very much. And this has been a fascinating discussion. As a non-technical, I'm an economist. I don't have much background in law. So this is fascinating, but I have one question that I would ask to every one of you is, I think Professor Ginsburg gave this nice story of the expansion of scope. And Professor Sook mentioned that human rights becoming part of the scope in some sense, and basically the judiciary taking part in making decisions and becoming politicized. We talk about firms in economics. We think about, okay, we need to regulate firms because they do bad behavior. But how do we regulate the judiciary if we believe in the future, if they continue this trajectory? Potentially, if this trajectory continues, how do we regulate the judiciary? Or should we just expect the judiciary to self-regulate?
I was just going to say yes. I mean, so my story about Chief Justice Roberts is kind of an attempt to self-regulate. Like, they see where they are, They don't want to be there. So they're trying to rein things in. And that, of course, can be done. And we have examples like in the United States history, you move from the Warren Court, which was very, very activist, to the Burger Court. And that's usually understood as an attempt to get the judges away from the politics. So it can be done, but it's not automatic. And the other possibility is that the power, the scope of activity over which judges have control is shrunk, made smaller by the politicians. They take cases away. They say, you guys can't decide this kind of thing anymore. They pass statutes and jurisdictional things. So that's another way to get these things under control. And maybe that's what's going to end up happening. I don't know in South Korea, but there's politicians certainly have tools. Like if you think about if you're a politician, you either want to appoint your own people to the court or shrink the scope of the court if you can't do the former.
Okay, if I'll go to some of the Q&A questions from the audience. So Cameron Whiteside asks, do the courts today resemble previous courts appointed by liberal presidents? Is this a new trend? Professor Heo, do you want to answer that?
Yes, so let me go to quick answer to questions. Yeah, so adding to Professor Sachs and Ginsburg kind of a comment about the role of judiciary or the capacity of the judiciary in Korea. So on how to say national decision making part in Korea. So we generally say that President Kim Dae-jung and President Roh Moo-hyun and President Moon is kind of categorized as a liberal president, and kind of liberal groups got the power of the Korea. But until President Kim Dae-jung era, I can say that the portion of the judiciary in Korea, in Korean national decision making, so that portion was very low, very small, and the level was very low. Still at that time, so the major big decisions was made in the politics. So up until that time, I should say most of them were made unofficial way. So I should say that until that time, the political process has not been much active or well developed. So the first time, so the Korean democratic process or political process was working as expected, like in the textbook of democracy. I can say that was from President Roh Moo-hyun's government, and that government is called a participatory government, something like that. So from that time, so many political voices burst into the area of politics, and somehow it succeeded and it failed, but somehow that deliberation and discussions were made inside the political process, and some of them are winning and some of them are losing. And those guys who lost in the political battle, in the political process, began to bring their cases to the judiciary to find out another answers or change the result. Maybe the impeachment of Roh Moo-hyun's case or the moving of the capital to Sejong City could be the iconic cases where the Korean people first witnessed that that kind of big decisions were made by the judiciary, so and the judges, so about whom they didn't know much about and what kind of people they are. And with that kind of this is the beginning of the judicialization of the politics. And after that, people and politicians got more interest in those areas and the people in the judiciary, and this made the politicization of the judiciary. This can be the short story of what happened. And even until Kim Dae-jung president and even to Roh Moo-hyun president era, so President Roh Moo-hyun's government tried to reshape the Supreme Court, but still there was high kind of constitutional restraint and political restraint to fully make it out, like President Moon's government picking up 13 justices among 14 justices. The maximum number was 5 during the no government. And that 5 numbers were still understood as the traditional elite judges. They were selected from still that groups. And maybe some of them could be, how to say, human rights friendly mind, but still their bases are still the elite group judges. So that was not that much, that could not do much impact like this incumbent Supreme Court justices. So the reason why that happened until that time was that there was no guarantee that those people in the judiciary, so as Ginsburg mentioned, they are quite good people and quite high profile people, but there was no guarantee that they were, how to say, wise enough or broad-eyed enough to think about the future of the country or the future of, so what is the real justice of the real people's every day. So they were very good and efficient in dealing with just civil or criminal cases, but there was no guarantee they can take care of big, how to say, political decisions or big human rights decisions. So that was kind of optimized status of between politics and judiciary until that time. But as I mentioned, so with the outbreak and outburst of people's voice after President Roh Moo-hyun's government, so this trend has changed a lot. And I can add one more issue. So after mid-1990s, the many, how to say, liberalist political movement activity inside the university or inside the campus has been the main power of the liberalist group. But somehow after mid-1990s, so not that the agenda and issues has been quite lessened in that field, and many players in that activist group came back to maybe campus or Shilimdong to study the traditional bar examinations, because they were quite high profile people and they were good at, how to say, concentrating on the task ahead. So many of them passed that bar examination and they flew into the judiciary as a judge. So right after that, kind of big group or stream of liberalist group has been began to be formed inside the judiciary, like that Uri-Bob study group or International Human Rights Studies group. Kind of the beginning of that group has been like that. So that began after mid-1990s. So that means even until President Roh's government, there was not enough pool of kind of judge lawyers group inside the court for the president to pick up and change the composition of Supreme Court. So we didn't have like the kind of liberal version of Federalist Society groups in Korea until that time. So that's my quick answers.
Okay, thank you very much. So unfortunately, like we had such a great discussion, we've already passed time, so we won't be able to get to most of these questions, but I just wanted to point out another one by Karis Templeman. Seems like part of the problem in Korea is the short term of court members and the selection mechanism giving power to the president and majority party so that one president can fill a majority of the slots. Are there any talks about altering this mechanism to weaken appointment power of the president by lengthening terms or requiring supermajorities to approve nominations or allowing the judiciary to put forward its own nominees?
I could just say one thing, which is obviously the short terms are an issue. You know, in Taiwan, I know they moved to this kind of, you know, hearings, confirmation hearings, you know, sort of copying the Americans. That hasn't really worked out that well. They've become extremely political, you know, and, you know, confirmation hearings in the United States are famous, as Professor Sook actually said when talking about Coney Barrett. You know, they just don't answer any questions. We get no information. It's like this kabuki theater where there's like this performance where everyone pretends. I never really thought about, Roe v. Wade before. It's interesting you mentioned that case. I'll have to look it up. So so that part isn't working very well. I don't see major reform in the appointments process, but Professor Heo can tell us if there's on the table in Korea.
Yes, in Korea, there's no supermajority requirement during the appointment process in the National Assembly. So the half of the people can, if they are half of the people agree, then he can be appointed by the president. Yes, but in the past, that appointment during the process of appointment, the ruling party and the opposition party were sharing some portions of their kind of power. So with that, the composition of the Supreme Court were divided somehow, even when the liberalist group were minority positions, so they could put some liberal judges to the court, but not as much as this Supreme Court.
Okay, well, thank you very much. This has been a fascinating discussion. I wish we could continue, and maybe we'll have future sessions discussing this in different degrees. But I just wanted to thank you again, Professor Heo, Professor Seok, and Professor Ginsburg for the fascinating discussion, and look forward to meeting you in the near future in person. Thank you again.